Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you today?
I'm very good. Thank you very much. Thanks for asking.
Good.
Sam, we're doing a very different kind of show today. Something we've never done before. This might actually go over an hour, and you'll see why in a moment, folks. But this isn't something that we've done before, and I doubt we'll do something like this in the future. Folks, this episode of HOA Hell is special. It's special because it's meant to address a problem that I see growing in our community. One where slick marketing is becoming more important than quality representation backed by actual experience, knowledge, and performance. A homeowner can have a strong HOA case and still lose leverage fast by hiring the wrong lawyer. The wrong lawyer wastes money, drags the timeline, triggers avoidable fees, and hands the HOA an advantage it didn't earn. More than ever before, mediocre lawyers with no real practical experience, but with a lot of resources and SEO marketing knowledge, have successfully made themselves out to be leaders and experts in this field. This special episode is a practical checklist aimed at teaching you how to figure out who the pretenders are and who the real HOA experts and pioneers are. It's about how to hire a law firm with real expertise in California HOA law, meaning the Davis-Sterling Act. Sam, of course, I'm going to be doing a lot more talking than I normally do. Mm-hmm. And that's usually most of it anyway. People do remind us of that all the time. And the show is geared that direction. That's kind of the way it is. Mm-hmm. And we don't have to go into details as why that's the case. It just is. But today it might be more so. So I am inviting you and begging you, jump in when you want.
Sounds
okay?
good to me, yeah.
There's so much content that I wanted to get out today for everybody, okay? Now, let me come clean to our readers. Obviously, I consider MBK Chapman, my law firm, to be the best law firm in the state of California when it comes to representing homeowners in HOA or neighbor disputes, okay? I think that goes without saying. I have a good reason for saying that. I've been practicing for almost 30 years, during which time I was a highly successful trial lawyer. But trial experience is only the beginning. I've been a lecturer, an author, and an educator regarding the homeowner side of HOA law during those 3 decades. Today, I'm going to teach you how to determine whether the lawyer you're about to hire to represent you in your HOA dispute is the right lawyer, or whether they're all talk with little substance. And stay tuned, because once you know how to do this and you put into practice the steps that I'm going to teach you, you won't be hoodwinked into believing that slick marketing, a podcast, or even a book maybe, equates to expertise or quality legal representation. But let me be clear. You should evaluate any law firm you're considering, including MBK Chapman, using the techniques you'll learn from this podcast. In other words, you should apply the same standards that I talk about today to my firm, to us, to my podcast, to my articles, my book, HOA Hell. The dedicated and highly trained attorneys at MBK Chapman, like Sam, have received the best training in the business. I've taught them the unique and effective systems and strategies that I pioneered and which made this firm and myself highly respected by the opposition, the very attorneys that we routinely go up against. And that respect wasn't given, it was earned, folks. And that's not the case with many other homeowner side attorneys, including the named partner that I will be alluding to throughout this show, whose reputation among veteran litigators in the HOA arena is, in my experience, been one of style over substance. You may begin to see why when I discuss that individual's published articles later on in this podcast. MBK Chapman's attorneys are the real deal. But don't take my word for it. Put it to the test. Read the articles on our website. Read the fact sheets on our website. Ask the questions. I doubt some of my competitors will welcome that level of scrutiny. Okay? Sam, anything you want to add before we kind of move on to the meat and potatoes?
No, you said it pretty well, Mike, in those introductory remarks. The only thing I would add to that, and that's largely echoing your sentiments, is you know the players. You've done this a long time. you have the credentials, the proven track record, and having been someone who's worked on the other side, representing HOAs, and now exclusively representing and advancing homeowner interest through our zealous advocacy.
That's why you're so valuable to us, by the way.
I appreciate you saying that. I see it firsthand. I see it in consultations that I do. I see it in client work I do. We have numerous attorney clients in various fields who come to us as homeowner clients, and they acknowledge what you said. They echo a lot of the same sentiments because they have looked into these things. They have the skill set to scrutinize
more than a normal layperson does.
Exactly.
And when I talk about that individual who we're going to be talking about a lot, and I talk later on, folks, about why I'm singling out a specific attorney. The reason and what we're hearing, it's not just from lay people, because most lay people don't have the background, hence the need for this episode.
That's right.
We're hearing this from attorneys, both the HOA side attorneys who we work with on a daily basis, who all have very strong opinions about this individual.
And the only addition I would have to that is it goes without saying that when you do your due diligence and you, as you put it, scrutinize, you know, based on the criteria that you will be now espousing and recommending to our audience, there's nothing improper about that. It's a very routine process that people with serious interests involving their castle, their homes, their interest in real property ought to do, because it can have significant
I agree
a significant series of implications in terms of rights, potential leverage. But also transparency. I think transparency is a huge part of it.
And that's actually, it's funny you said that, and I think we'll talk about that later. But for everybody that's read my book, or people that will read my book, I use that term. I can't tell you how many times. In fact, the entire chapter 12 is how to build leverage. And it's a technique. It's unique technique I came up with on handling HOA disputes. From the homeowner perspective, right? From the layperson perspective. And I talk about building leverage. And so it's funny that you say that, because that's really the bottom line, okay? And unfortunately, and we're going to get into this later. I don't want to give too much away now, but it's unfortunate that in today's day and age and today's technologies allowed people that in the past could never have been thought leaders or considered leadership in a certain area without actually earning it. But it's totally possible today, and that's the problem we have. And you see it in their work, their published public work. And that's what we're going to talk about, because that's dangerous. And that's why I'm speaking out. All right, so we got that out of the way. I think right now, why don't we, I think it might be helpful to talk about why this problem exists and why it's getting worse. So before we go on, folks, let me stop for a moment to lay some foundation that you're going to need to understand why I'm spending time talking about the things that I'm talking about before I actually get to what I call the 3 filters, okay? What's changed in the last few years is not the law. What's changed is who homeowners are trusting and why. We now have lawyers, some of whom have had very large litigation firms with absolutely no trial experience, with very little practical litigation experience, with a shallow understanding of the Davis-Sterling Act, a very non-nuanced, shallow understanding, with little to no homeowner side litigation history. We have a lot of law firms that are real estate law firms, but do very little HOA law, and yet they hold themselves out, right? The problem that I'm tackling in this episode is that those changes have allowed certain attorneys, including arguably the largest one on the homeowner side, who appear to have embraced all the hallmarks of heavily relying on AI, and who have figured out how to conduct online marketing most effectively, thus allowing them to dominate search results. That alone, though, isn't the biggest problem. Those things are important to me too. I utilize online marketing. Of course I do. But the biggest problem is what such attorneys are publishing and why their online dominance gives people a false understanding of their true knowledge and experience. That's the danger. By publishing constantly and saturating search results and prioritizing SEO volume over accuracy, these lawyers have created the appearance of authority without the substance to support it. That's dangerous. And that matters to me a lot. Fortunately, though, when legal knowledge is thin, it shows up in writing, if you know what to look for, which is what we're going to talk about today. Folks, the same self-proclaimed thought leader, this is the person I've been alluding to a little bit, and we will be alluding to throughout this episode, is the one who's published these so-called articles, most of which are, in my opinion, and in the opinion of scores of experts in this field, sloppily organized SEO dumps that contain grammatical errors, misstatements of law, missing nuance, irrelevant statutory citations, and fundamental conceptual mistakes. And I say this because, and not all of everything this person writes does that, but much more than should be. I would say at least half has one of those issues in it, okay? I believe that they reflect a superficial knowledge of the law. I believe that's where it comes from. Either that or somebody else is writing or something else is doing the writing. It's got to be one of them. That's my opinion, okay? Even worse, because of these attorneys, and there's more than one, okay? We're not just talking about one. But because of these attorneys' heavy online authority, publishing such negligently drafted articles actually does an incredible disservice to HOA members like our listeners, who invariably, when they come across the work, when Googling relevant terms, don't have any reason to doubt those people's purported expertise. So they end up believing to their detriment the things that they're reading. And that's a real problem. Am I wrong about any of this?
You're not wrong, Mike. In fact, I can personally attest in consultations I've done where they've been exposed to misstatements and inaccuracies through these other sources that you're alluding to.
That you have to correct.
That I have to then correct.
And then point them to us. Right?
I in fact, do a screen share whenever it's a Zoom or if it's in person, these consultations, and I share our articles, our fact sheets, our authority that you diligently work on and you do your research and the way your brain operates, like you are very meticulous in that process, and I highlight that in these consultations or with actual clients, and we correct those misstatements. And the one additional remark I would make that is consistent with what you're saying is, look, it's perfectly fine to self-promote, to engage in advancing your business interests and trying to enhance your footprint and SEO profile online,
of course,
using the tools that are available in this day and age.
You'd be a fool not to.
But here's a problem. That process cannot be at the expense of substance, of accuracy, of actually being in concordance and compliance with operative law and making that clear to your reader and audience.
Agreed.
And most importantly, it cannot do them a disservice in terms of misleading them to a point where they're at peril or it prejudices their case and leverage in cases.
Right. And even though nobody should be relying on anything that we write or that any other lawyer writes, okay, we have disclaimers for a reason. Right. Don't rely on this. Don't rely. But people still do. And I kind of know that. And they shouldn't. They shouldn't rely on anything I write, even though what I write is, in my opinion, 100% accurate. And by the way, I make mistakes. When I see them, I change it. I'll go and modify an article if I make a mistake or I go too far. I'm not perfect. It's not a mistake here and there that matters or a typo here and there. It's when it's consistent. Here's the problem. Let me address your SEO thing, okay? SEO and marketing is very important to me. We pour lots of money into that. But it's not more important than the product I deliver. It's equally important or slightly less important. You know as well as I do, because I know you come in very early. I get in between 2 and 3:15 every morning.
You do?
Okay? I spend hours a day, every day, writing all of the stuff that goes up on our website. I write the fact sheets and the articles, and I write constantly, but I research.
You do.
Okay? It's not hours of time spent only writing. I include in that time the research, making sure that what I'm saying is accurate. Okay? The problem I have is that there's no way that, based on some of the things I've read from some of our competitors, there's no way that whoever's writing those articles is spending as much time or even any time reviewing the law before they write, because there's no way those mistakes could come out.
One quick comment.
Hold on.
Yeah.
I recently published just a couple days ago, I published a fact sheet on specific mistakes from the individual I'm going to be alluding to a lot in this episode. And again, I explain later why I focus a lot on one person. I do explain that, even though there's lots of people in that boat. But in one of his articles from late December, in talking about the new laws in 2026, HOA-related laws, he made 3 fundamentally incorrect statements, which are literally, it's not a nuance or a matter of opinion. It is, he's saying it's nighttime and it was daytime. I mean, it was that blatant. And I had to point him out because it's crazy. It's just crazy. So what did you want to add, though?
Just for the audience and the listeners, a very brief peek behind the curtain in terms of what you were just addressing. when you get in that early, and just the way you operate, and I can personally attest to this because I've seen it and I've seen the work product. You cross-check your work, your research, just because of how meticulous you are, and that's how you're wired.
To my detriment sometimes.
And yeah, many of us, in fact, we endearingly, just kind of.
I get made fun of. Yes.
Laugh at your process, but you, to your credit, cross-check that with multiple reputable sources that we know within this industry, within the legal practice.
Right.
You look through those avenues as opposed to a quick shortcut where you're just punching it into some platform and it spews out and spits out something that's largely unreliable. So just that peak for the audience, and this is, by the way, consistent with what I emphasize to in consultations that
PCs,
I do to PCs, like these are potential clients or actual clients, to kind of enhance their experience and to also kind of facilitate our dialogue and discussion with them, because the more educated these folks are, and we don't take that process for granted, the more we can collaborate with them and jointly advance our cause.
The better they'll understand what we're trying to tell them and how our advocacy. We get a lot of, sometimes we have unhappy clients who, why is this taking so long? Why is this? And they don't understand that, we don't have control over the timing. For example, in the pre-litigation process, once, if you send an ADR demand, the HOA has 30 days. That's a statutory deadline. They can wait 30 days. I can't make them give us a response faster. And then once they respond, let's say they accept a mediation demand, right? An ADR, and it's going to be mediation. They accept that. Then the code says that the parties have 90 days to complete it. Now, that can be mutually extended.
Correct.
But we can't then forestall, let's say it was a mandatory ADR situation under the code, right? We can't decide to go right to litigation in less than the 90 days because the statute gives them that time. We explain this. I do all this writing so that you can point it out to PCs.
Yeah.
Also, I don't know if you said this, but we often have PCs come to us who've read some of the things from some of these other websites and say, well, wait a minute, this says, and this person, and then you pull up mine and go, actually, that's just wrong. Sorry about that. We have no control over that person's code, but this is the actual.
That is exactly it.
Anyway, all right, folks, look, because I care so much about arming you with accurate and effective information about how to deal with your HOA, when I come across so-called articles like the ones that I'll be describing later, in which I go into a lot of detail for a good reason, I feel compelled to act, if for no other reason than to provide you, the public, with accurate information. It's also why I'm spending so much time on the articles related portion of this episode, and you're going to see I spend the most. I have 3 filters. That one's the biggest one. So bear with me, please, guys. There is a reason behind why I've organized this episode the way I have. Anyway, because of the misinformation coming from a particular author out there, I began writing fact sheets and articles aimed at correcting those errors. For example, I recently published a fact sheet aimed at correcting some gross misstatements of the law, and this is what I just talked about with Sam a few seconds ago, that were related to California's balcony law that came out in a recent New Laws for 2026 article by a particular author and self-reported thought leader in the HOA space, okay? In just a couple of very, very short paragraphs, the author of that article made 3 glaring and serious misstatements of the law. And I'm not talking about, again, opinion or hyperbole. These were misstatements of the law. Okay? Let me give you an example. First, this person wrote the following, and I'm quoting. SB 326 sets a January 1st, 2026 deadline for inspections of balconies and other exterior elevated elements, and then it goes on to complete the sentence, end quote. Okay? It's a simple statement. Okay? The author went on to reiterate that point when he wrote, just a few lines later, okay, the January 1st, 2026 deadline for SB 326 compliance represents one of the most consequential 2026 HOA legal trends. California condominium associations with 3 or more units must complete exterior elevated element inspections by this date. These inspections cover balconies, decks, walkways, and any load-bearing components more than 6 feet above the ground that are substantially supported by wood, end quote. Now, everything I said from California condominium associations to the end, 100% accurate.
Yes.
Okay. What was inaccurate is that January 1st, 2026 deadline. I'll get to that in a moment. Okay. Yeah. Because in both of those quotes that I read, his reference to the January 1st, 2026 deadline were flat out wrong. Folks, California's balcony law, codified in the Davis-Sterling Act in Civil Code Section 5551, required all HOA inspections of applicable elevated elements, such as balconies, to be completed by 1/1/25, not January 1st, 26. It's a year off. Okay?
Deadline has passed, and it's clear, unequivocal.
In my recent fact sheet, I explained why this purported expert was dead wrong, or at least I gave my theory. Obviously, I'm not in that person's mind, and I don't know. I gave a theory, and I backed it up with what I said I thought was actually going on and what he was probably getting confused about, okay? Contrary to what this thought leader wrote, you'll remember this conversation with me, the California legislature never extended the SB 326 inspection deadline to HOAs. Here's the problem. This attorney was obviously confused. The fact is that the extension referenced by this author, the 1/1/26, actually relates to SB 721, which applies only to apartment buildings and not HOAs. In fact, it explicitly excludes common interest developments.
Correct.
It excludes common interest developments or HOAs, okay? So now, again, to be fair, initially SB 326 and SB 721, they did have a 2025, January 1st, 2025 deadline. But the legislature, through SB 2579, which came later, extended the SB 721 deadline by 1 year. It moved it from 1/1/25 to 1/1/26. Guys, that only applies to apartment buildings. It doesn't apply to HOAs. That bill explicitly excluded common interest developments, or HOAs, from that extension. Unfortunately, and this is unfortunate, that wasn't the only misstatement of law that this attorney made in that very, very short snippet on SB 326. Remember, this article was about other issues that are going to be important in 2026 for HOAs. SB 326, the balcony law and the extension, that was just one issue. It was a very short part.
Right.
Those two paragraphs that he talked about, the deadline being 2026, what were the only two errors he made? He made another one, okay? He went on to write, quote, qualified inspectors, including licensed architects, structural engineers, civil engineers, and certified building inspectors must examine a statistically significant sample of elements, end quote. Now, what he's talking about there are what the deadline was about was the mandatory inspections. And for most HOAs, and I won't get into the exception, if you want the exceptions, go listen to our very first podcast we've ever done on the balcony law, or look at my multitude of articles and fact sheets on the balcony law. But what that was about was the initial inspection deadline for those EEEs, the exterior elevated elements, which include balconies. So it's called the balcony law, okay? Now, the code, and remember, we talked about there's one code section here that is what is called the California balcony law, and that's Civil Code 5551. That code is crystal clear about who's allowed or authorized to perform those inspections. And all that attorney had to do was look at that single balcony law statute to know that what he wrote wasn't true. Why am I saying that? Simple. Civil Code Section 5551B1 states that the only people who can perform inspections for HOAs, exterior elevated elements, okay, are the licensed architects or civil or structural engineers.
Correct.
Period.
What's
excluded from that list is anybody else, including, as this other attorney wrote, certified building inspectors. The code does not allow certified building inspectors to perform these EEE inspections under the balcony law, the deadline of which was a year ago, okay? They are not authorized to do that.
Correct.
Why would this attorney write that? Again, probably, and I'm guessing here, probably got confused with the other law that relates to apartment buildings, because in that law, structural engineers, civil engineers, licensed architects, and, is this a shock? Certified building inspectors are authorized to do those inspections of those elevated elements in the apartment buildings.
SB 7.1.
And so this attorney very clearly confused a completely different law with the HOA law that this person, as a so-called expert and thought leader in this field, should have known in their sleep. There is no way that that person should have ever written that statement in an article. It's just not possible.
And it's not a minor mistake. It's
It's
simply
huge.
way off, not applicable to common interest development.
And I'm going to tell you why. I'm going to tell you why it's not a minor mistake, okay? And let me be clear, okay? The author of this article somehow managed to fundamentally misunderstand a very basic law that he was claiming expertise in, okay? And as you're about to see, evaluating a law firm's website publications is what I call the first filter in evaluating whether you should hire that law firm to represent you in an HOA dispute. Is there anything you want to add?
No. I think you were rather comprehensive with that. So conflating those two, it's not a harmless minor error, and it's really misleading. And I would imagine, and I've actually encountered this to some degree in consultations I've made, where folks rely, misquote, and use the January 1st, 2026 deadline argument, and essentially we have to then correct them.
Well, I want to interrupt you for a sec because it's what you just said that I didn't say a minute ago, and I want to say this.
Sure.
We eat lunch together every day. You and a couple of other of us have a game we play. I think we've talked about that on the air. We play a game every day at lunch.
Yeah.
And I look forward to that, okay? And I hope you do.
I do.
It's a lot of fun.
Yeah, it is.
Okay, and by the way, of the three people that play this game every day, I'm the third best, meaning I'm in last place. I don't have the skill set for this game that the other two players have, but it doesn't matter. It's still fun, and I love it. Anyway, we talk sometimes in between rounds. We talk.
Yeah.
And you specifically were talking about a PC who was, and this came because obviously this was their HOA, had not done the inspection yet. And this person was a board member who was coming to us on their individual capacity and was very confused. And like, wait a minute, we're not non-compliant. We're good. This was in December, by the way. This was before. Okay. And he says, we have it scheduled, but we're good. No. And you had to correct this person. It was when you came to me that I decided I got to write something. That's one of the impetuses that led to my writing the article that I just published, or the fact sheet that I published the other day on this SB 26 issue, was what you told me. This is real people coming to us and
Absolutely.
Inspiring.
Yeah.
You know, I get most of my ideas for what I should talk about in the podcast or what I should write about, okay, come to me from two sources. They come to me from our PCs who often become clients.
Yeah.
And it comes to me from people who listen to the podcast or people who write into the law firm. They've read something I published, asking questions or stuff like that.
Absolutely.
Okay?
Yeah.
That's where they come from. Some of them come from our brains, but most of them come from real people because those are the ones that are real.
Real life, not some
Real
theory,
life.
not some just
Not
online
ivory tower
search.
stuff.
Yeah, exactly.
We don't write about blockchain technology, and I probably won't ever do an article. On potential tax related issues that might it be relevant to an HOA case, because if I've ever seen that, it's probably been so few times it's not worth it. I'm not going to waste my time just for SEO. It's got to actually serve a purpose. Okay? So anyway, that's where we're at there. Okay, now, so this leads us beautifully into the first of the three filters.
Okay.
Okay? The first filter is this. Start with the attorney or law firm's website. And by the way, folks, I'm going to spend by far the most time on this filter because this filter is where you will be able to eliminate most of the pretenders. It's not going to be enough to eliminate most of the people you might interview, but it'll eliminate the pretenders. And I don't know if I'm going to bother defining pretenders. I'm just going to have to figure out what I mean colloquially. Okay? So with that understanding, let's talk about this first filter. Okay? Now that you understand why this problem exists, I guess we can start talking about where the solution actually starts. Before you ever schedule a consultation, before you ever talk about fees, and before you ever let a lawyer of a law firm sell you on their experience, start with the firm's website. That's where you go. Not the testimonials, not the reviews. Yelp reviews and Google reviews, folks, they can be purchased. There's lots of ways that you can create fake accounts and do that. We know of people that do that in the industry, and that's okay. That's up to them. We choose not to do that, but it's certainly out there, and I'm sure lots of people do it. I'm sure more than I think do it, okay? But the point is they can be purchased. Don't rely on the slogans or polished videos, okay? Even if we have polished videos on our website, don't rely on those, okay? You can put, if you are willing to put a lot of money into a video, you can come out looking like a, I don't know.
Hollywood A-lister.
Yeah, Hollywood A-lister, okay?
Yeah.
You focus on one thing and one thing only, the quality of the publications or the writing, what that law firm is putting on as public face. This step alone will eliminate a shocking number of bad options, okay? So let's talk specifics. Here's what you're looking for. 1, what percentage of their articles are about HOA law? If a firm claims to be an HOA authority, but only a small fraction of their content deals with HOA disputes, that tells you what you need to know. That tells you where their HOA law sits in their practice, okay? 2, can you tell whether or not HOA law is actually a core part of the practice? You should look for more than merely occasionally handling HOA cases. Like, we're a real estate firm and we do a lot of real estate and we do HOA law in there as part of that. No, that's not enough. Davis-Sterling Act is a whole set of statutes in the Civil Code which are unrelated to anything other than HOAs, okay? So occasionally handling HOA matters, not enough, in my opinion, okay? Being experienced real estate lawyers is not enough. Just said that, right?
Yeah.
Look at their articles in other publications, because a real HOA-focused firm publishes HOA-focused material consistently. All of their stuff? No, of course not. Our firm does business and other things like that, and I write once in a while, I write business-related articles. But if you look at the percentage of HOA versus non-HOA, it's overwhelming, okay? So ask yourself, do they regularly write about HOA records or elections or fines or assessments or architectural control, ADR, fee shifting, neighbor disputes, all the stuff that I write about? Do they write about that stuff regularly? Or are HOA issues just one category among many that kind of shares equal space, okay? Number 2, and I might have said 2 before, I apologize for that. This is actually number 2, I misspoke. How's the quality of the writing? For example, do you see consistent or repeated typos or grammatical errors? Take a look at your screen. Take a minute to look at that. Those are from another attorney who we will speak about more later on, okay? Okay, so first is typos or grammatical errors. Here's another one. Do you see consistent or repeated articles that are written in a way that make it harder for you, the reader, to follow? For example, does the article just contain headings and words on a page with no indentions or bullet points or a way for you to easily follow a progressing train of thought? Okay, is it user-friendly is a good way to say that, okay? Next one. Do you see consistent repeated things that I call word salads? Take a look at what's on your screen, folks. Read that. That's a word salad.
It is.
Okay? I have no idea what that means. Okay? It's just words put together, maybe for SEO purposes, but it doesn't make much sense. Okay? Do you see consistent use of articles that read more like keyword dumps stitched together to satisfy search engines rather than you, the reader, the end user? Okay? Next one. Do you consistently see blatantly nonsensical sentences? Take a look at the graphic on your screen now and take a minute to read that. Folks, judgment against an HOA would arise from the HOA's failure or misconduct, not from the homeowner's failure to pay fees or because of a violation of the governing documents. While the words are in grammatical order, the sentence described is a legal impossibility. A homeowner's default resulting in judgment against the HOA that they owe money to. And thus, that makes the statement conceptually nonsensical. But that wasn't the only blatantly nonsensical statement contained in this particular article. No, this author, whose firm is touted as a leading litigation firm, went on to go after the HOA's poor employees when he wrote, take a look at what's on your screen now. These are quotes. Folks, I'm pretty sure that all of you recognize the massive problem with that statement. Wage garnishment is a tool used to collect money from a debtor's wages. Since the HOA is the employer and the judgment debtor in this scenario, garnishing the wages of its innocent employees to pay the HOA's corporate debt is legally impossible and gibberish in the context of debt collection law. By the way, it's also sort of mean. Okay? Folks, for the purpose of time, I'm only giving you a few examples from this author's so-called article library. Over the last year or so, I've literally gone over and found dozens of other errors, grammatical mistakes, blatant misstatements of the law, lacking of nuances, citations to irrelevant law, etc. in this law firm's publications. Now look, guys, nobody's perfect. A few typos, a few mistakes of law now and again, or misstatements or overstatements, it's perfectly normal, okay, and acceptable. Of course, if they catch it, it should change. They should modify. But when it's much more than that, when it's more frequent than once in a very, very long while, that's a big problem. Because poor writing, ladies and gentlemen, is not cosmetic. It's diagnostic. Lawyers who cut corners in public-facing work cut corners in real cases. Folks, let me say that again, okay? Because I think it's an important point. Poor writing is not cosmetic. It is diagnostic. Number 3, jurisdictional clarity. Okay? What do I mean by that? California HOA lawsuits are almost exclusively governed by California statutes and litigated in California Superior Court, right? That makes sense.
100%.
Okay? Now, sure, it's possible you might end up in federal court under a very few scenarios. I can't remember the last time we were in federal court in an HOA case. I can't even remember it. But I allow for that possibility, okay? Folks, if you see references in an article to another state's laws or federal statutes or federal rules, like the Federal Rules of Civil Procedure, that don't seem to have any application, or you see procedural rules that don't govern HOA cases, that is not sophistication. That's just dumb. I'm sorry. That's just dumb. Folks, let's revisit the self-described HOA experts articles that we've been talking about, because lo and behold, I've got examples of that person's articles related to the jurisdictional issues we're talking about. In an article, and I'm going only by what was stated in the article. I'm just going by what I've been told or what I've read, okay? In an article where the sole reference to the intended audience appeared to be this statement, quote, homeowners in California are granted various protections and remedies under both state law and the governing documents of their homeowners associations. Okay, I like that. It's a good statement. Tells me who my intended audience, that's me, right? Tells me what we're going to talk about in this article. Okay, I accept that, all right? So far, so good. But the author's article goes on to say that, take a look at what's on your screen, folks. Take a sec to look at that. Huh? Florida statutes? Florida courts? Lest you think that that was just one-off error, this same author goes on in that same article to say, take a look at your screen and read that. It's from the same article. Folks, let's unpack that for a second, okay? Now, you already know that citation to Florida courts and laws here is nonsensical. But did you catch his reference? Sam, I know you did. Did you catch his reference to the Lanham Act? Let me just tell you, folks, the Lanham Act is a federal statute that governs trademarks and false advertising. I can't think of a scenario that it has any application to a homeowner suing an HOA for fraud or misconduct unless somehow the HOA violated a particular homeowner's trademark in some way. And I can't, and that's not certainly was even remotely what this article was about. I mean, if it was, that would have been okay, but it wasn't, not even close. And I know you read this article because we've talked about it in the past, and you had somebody ask about it. One of your PCs asked about it, okay? That's how I came to find out about it, okay? His inclusion of the Lanham Act isn't just a mistake. It's a symptom. It has all the hallmarks of an AI hallucination, where a computer program stitches together impressive sounding legal terms that actually have zero application to a particular case or set of circumstances. But here's the scary thing. If a firm is comfortable using unvetted AI or unvetted material written by somebody else, or unvetted material written by the attorney who never actually proofreads his or her own work, and gives it to the public as information on their website, you can bet they're using that same unvetted AI or that same carelessness to handle your confidential motions, your trial briefs, and other court-related items, right? You aren't paying for a lawyer subscription to a chatbot or for ChatGPT or Gemini or whatever it is out there. And you're certainly not paying for some non-lawyer to write things where a lawyer's not going to be reading what they write. You're paying for a lawyer's brain. When the public content is a hallucination, the work product is probably going to be a liability. But that's just my opinion. Or how about this gem from another one of this same author's articles? And this article was titled, Appealing Adverse Decisions in HOA Lawsuits. Folks, take a look at this statement that's popped up on your screen. In that article, in which the author wasn't sure, to me, whether he was writing about appealing adverse decisions in HOA lawsuits or appealing a board decision after receiving, a violation notice, this thought leader wrote, quote, homeowners associations play a significant role in maintaining community standards and resolving disputes in neighborhoods, end quote. All right, so far so good. That's accurate. I can understand and appreciate that. Let's move on, though. He then goes on to say, quote, however, when homeowners face adverse decisions in HOA lawsuits, they may wonder if they have any legal recourse, end quote. Again, fantastic. I'm following. Everything's great. We're talking about appealing a bad verdict in a lawsuit with an HOA. I'm still with the author here. I have no issues. But then, in the very next sentence, he goes on to say, take a look at your screen. Quote, if you're a homeowner in California who has received a violation from your association or has been involved in an HOA dispute, it's important to understand your appeal rights and the appeal process available to you, end quote. Okay, now I have an issue. Everybody wait, okay? Now we're talking about HOA disputes, like whether I violated a rule or I'm mad because the board didn't approve my construction plan, something like that. Clearly, the author's no longer talking about appealing a verdict in a lawsuit, at least to me. And what's even more clear to me is that whoever wrote this article believed that appealing an adverse decision in an HOA dispute was synonymous with appealing an adverse judgment with the appellate court. That's how it appears to me, based on the words used, that this attorney doesn't understand the difference between appealing a extra litigation issue with your private HOA and something in the court system.
Well, judicial versus non-judicial. Very easy.
Yeah. Thank you. Yeah. Okay. Thank you. Yes. But folks, let's set the author's, in my opinion, obvious confusion about the difference between appealing an adverse decision outside the context of litigation and appealing an actual verdict from or following litigation. Let's set that aside for a second. Okay. Let's focus on a different kind of confusion plaguing this author in this very same article. In a section of the article, he had a heading called, quote, Final Judgments in HOA Disputes, end quote. And in that section, this attorney wrote, take a look at your screen, and I'll read the quote out loud. Quote, if the case involves specialized areas such as Medicare Advantage or Medicare health plans, the Independent Office of Appeals may also be involved in resolving disputes. For tax-related cases, the Merit System Protections Board or the IRS Independent Office of Appeals could offer avenues for challenging decisions, end quote. Remember, I'm reacting to what this article has been about so far. It wasn't like this attorney set out a set of facts which could have included somehow this kind of tax issue or Medicare issue. Had the hypothetical or something been offered, had some sort of hypothetical been offered in the article that explained that sentence maybe would have made sense. Mm-hmm. But nothing of the sort.
No nexus, no relationship to those things, yeah.
Now remember, folks, this short section was titled Final Judgments and HOA Disputes. And this article at least from the a sentence from the beginning, appeared to be about California HOAs, right? So, a section that is dedicated to final judgments and HOA disputes, I don't understand the reference to the Merit System Protection Board. Folks, the Merit Systems Protections Board deals with federal employment disputes, okay? And all of you probably know that the IRS deals with tax disputes. Including either of those in an article about California HOA disputes, which again are almost exclusively litigated, and I say almost just to be careful, litigated in state court under state law, offering those agencies as an avenue for a homeowner to challenge the decision is, under the circumstances, gibberish. It's gibberish. Ladies and gentlemen, this simple filter, look at the firm's publications, costs you nothing, but it tells you a whole lot. Sam, I know, as I warned everybody, I'm doing 99% of the talking in this one, and I apologize for that. But do you have anything you want to add on that section before we move on?
No, I'm just nodding and really, I mean, you're covering it all. I mean, there's so much more to be said in terms of real life scenarios that we encounter where misstatements, inaccuracies, things of that, we're having to rectify that and address it. That said, no problem on our end in doing so.
Oh, by the way, it creates, it does make your life, not our, because I don't do the consults as much as you. I do some, but not nearly as many as you. It makes your life harder, or my life harder at times, because they insist that this other person who's such a big authority, they insist, but, and we have to explain without being unkind.
I'm okay with it. I've a pretty, I would say, long bandwidth in terms of patience and tolerance for folks who are misled, and then me having to kind of rework that with them.
You are a good person.
But decoupling that or reversing some of the damage that's done, because they are, I mean, to your point,
they've been miseducated.
Relying on these sources as a wrongfully. I mean, these are not legal professionals.
And again,
keep this in mind.
They shouldn't rely.
As a legal authority. And these are not treatises, you know. These are just, you know, articles like full of misstatements and misleading information, and then unfortunately,
and lack of nuance, overly broad statements that actually will mislead you, even though they might be accurate. You're right. Here's the thing, though. Again, don't rely on anything. Don't rely on what I write. Don't rely on what anybody writes. Take what I write, and then if you want to act on it, check with an attorney. Either hire us or hire an attorney where you have them under contract, and now we have a fiduciary duty to you as an attorney-client. Then you can rely. Okay, that's how it works. But that's the first filter. Let's go to the second of our three filters. Trial experience by the top leader of the law firm as confirmation, not a substitute. I'm going to be very clear here. Trial experience by the named or managing partner of the law firm is a must. And I'm not just saying that, I'm going to tell you why I'm saying that. Okay? We need to clear up, though, a common misunderstanding. There is a massive difference between a litigator and a trial lawyer. A litigator manages the process of litigation, motions, discovery. They do the office work. Now, they're often the same people, but they don't have to be. In our firm, we have people who are litigators. They aren't trial lawyers. We also have trial lawyers who do the litigation and the trial work. So it can be both, but it doesn't have to be both. But they are different.
Right.
Okay? A litigator manages the process, as I said, motion, stuff like that. But a trial lawyer is the finisher. They're the ones who know how to walk into a courtroom, select a jury, look them in the eye, present the arguments, deal with witnesses, and win. Okay? But there is a hidden third category. Okay? It's not just litigators and trial lawyers anymore. And this is me speaking. I came up with this on my own. I invented this. Okay? But I think it's valid, and I'm going to show my work. I'm going to show my work so you can judge whether or not I'm making this up. You decide. Whatever you decide is going to be correct for you. Okay? There's a third category out there that, in my opinion, has only become possible with the advent of AI and online Google marketing. And I call that third category the career spokesperson or the career promoter. In this scenario, the face of the firm, the person that's writing the articles and defining the aggressive vision of the firm, has spent almost their entire professional life outside of the courtroom and outside of actually working on real cases. So what I call the career spokesperson or the career promoter is a person who has spent maybe they did a year or two of law and then spent the rest of their careers basically as rainmakers, generating business. But actually stopped seeing clients, stopped writing briefs, stopped appearing in court, whatever, okay? All those things, okay? Now, those lawyers, they'll have a bar card. They'll be members of the bar. They'll be Esquires after their name. But if they haven't personally handled the core work of litigation, or if they haven't handled that in years, then meeting with, and what I mean by that, if they haven't met with clients or handled depositions or, attended evidentiary hearings or engaged in tactical battles, they don't have to do all of that. A lot of senior attorneys step back from day-to-day aspects of a case. I do. I've stepped back. I don't go to court anymore. I have people for that. But I meet every day with my litigators, and they seek my advice. We have office hours where they seek my advice on numerous cases, and I'll bill a point 2, a point 3 on lots of different cases, giving my advice on, okay, next let's try this, or let's do that, or let's get this expert in here. Let's do it now rather than later. Mm-hmm. That's the sort of thing. That's still that satisfies, right?
Round-table issues, yeah.
That's right. But the professional promoter, the professional, this third category of lawyer has stopped all of that because their job is to write articles, create SEO, meet with SEO people and video people. It's basically they're glorified marketing directors. Okay, they're professional rainmakers. That's all they do, and this creates, in my opinion, what I call the paper tiger law firm. I take the paper tiger from martial arts, which will be an issue we'll cover another time. That's a big part of my life, as you know. Mm-hmm, okay, so that person is going to have very little or no recent personal experience in the trenches, okay? And it's likely that they lack the scars and the instincts that come from years of actual practice. What these people, these promoters, are selling is a trial-ready image of their law firm based on a theory of law, but not on the quality or reality of it. They aren't building a case for a verdict, okay? Because they don't know how. They're building a marketing machine designed to capture a retainer while someone else entirely does the heavy lifting. That's the lawyer, this promoter lawyer, has litigators working for them, under them. They might even be partners or non-equity partners, but they work for him. He's the face of the firm. The firm's named after this person, something like that, okay? That doesn't change that head guy's or gal's moniker as the professional marketer or professional promoter, okay? Law firm managing partners who have personally carried cases through contested hearings and trials are much better at recognizing risks much earlier, identifying and recognizing risks, understanding leverage, and knowing when settlement posturing is hollow and when there's something to it. And they may need to take a second look at their case. Let me say it differently. It's not enough for a law firm to employ competent litigators. If the head partner, the main guy or gal, the main shareholder, whatever it is, and the face of the firm has no personal trial experience, none. It doesn't matter how many incredibly gifted litigators that person has working for him. Now, I have a couple of reasons for saying this. Again, I always will say, don't take my word for it. Listen to my reasoning and see if you agree. Here are my 2 reasons for saying why I believe that to be the case. You judge whether I'm right or wrong. Number 1. A managing member or the face of the firm with no trial experience often relies on legal tropes and cliches in their content because they don't have the war stories or the nuanced understanding or nuanced knowledge of trial dynamics to write with any kind of authenticity. Okay? Sophisticated clients and opposing counsel always know the difference, which is why I want to remind you, I said at the very beginning that there were a lot of lawyers on the other side who believed as we do, and I think I'll say this, I cover this in a few minutes, who look at this person and basically see this person as more substance than actual knowledge or authenticity or professional gravitas, right? There's a reason for that, because people on the inside, insiders from both sides of the aisle, from pro HOA and homeowner side, lawyers know who the pretenders are. They just know because they know what sounds BS and what's trite phrases and statements of obvious truths that don't tell anybody anything. They just sound good. And they're easy. It's like rice. It's easy to eat. It's easy to digest. But if you think about it, it doesn't solve anything. Okay? So these people understand theory, but their marketing becomes a hollow promise. Okay? Number two, second reason I feel the way I feel. There's a moral hazard when the face of the firm sells a service, trial expertise, that they themselves can't personally provide or vet or train or improve in their people. While they employ litigators to do the work, the managing partner's inability to mentor those litigators in the specific art of trial persuasion means that the firm's vision is built on a foundation of secondhand knowledge. I'm going to say that again. The vision of that firm is built on secondhand knowledge because the one producing the vision doesn't have firsthand knowledge. I hope everybody understood that. Those are the two reasons why I believe what I believe and why my second filter here is my second filter.
Yeah.
Okay? And that's why, as the single question that you should ask to satisfy my second filter, it's one question. It's very easy. It's a yes or no question, and you insist on a yes or no answer. Are you guys ready for the question? Are you ready for this question, Sam?
Go for it. Yeah.
Okay. Here's the question. Has the named partner personally conducted both jury and bench trials as lead counsel or as first chair? That's the question. I don't want to hear, well, we have a very experienced litigation team. I don't care. That's important, of course. As I said, I don't do day-to-day aspects of cases, and I no longer do trial work. I retired from active trial work a few years ago, okay? I've done numerous jury trials, numerous bench trials, and I got sick of it, so I was done. I employ other people to do that, but I still train my people. I still train my lawyers on taking proper depositions, on legal writing and briefs. I routinely train my people. I can do that because I have the experience and the knowledge to share, so I can shape that vision. Because no matter how well-intentioned or well-meaning, regular associates or even partners at the firm that aren't the face of the firm aren't setting the agenda, okay? So you ask that question. Has the named partner, has the main partner, has the managing partner, whatever the words you want to use. I say named partners in the firm would be important. Has that individual or those individuals personally conducted jury and bench trials as lead counsel or as first chair? Yes or no? Then you listen for the answer. Just listen, okay? You're not looking for volume claims or team references. We've got this best team, or we've got lots of lawyers, that have all this knowledge, blah, blah, blah. I don't care, okay? You're looking for a clear, direct answer, yes or no. Trial experience does not replace HOA knowledge. I grant you that. But HOA knowledge without the litigation judgment is dangerous. You need both. And a trial experience only matters once the earlier filters are satisfied anyway. Bottom line, if the answer to that question is no, or they don't give you an answer, or they give you an answer that is not a yes or no, or a yes in particular, go somewhere else.
Yeah.
You do yourself a big favor if you just go somewhere else. Anything you want to add to my second filter?
No, I mean, you said it really well. The only thing I would say is that the posers versus serious players oftentimes will reveal themselves to the discerning eye, and employing some of the tests that you're espousing, some of those tenets that you are emphasizing to our audience. I think those are fantastic ways in the aggregate to help them discern who the posers are versus the serious players.
And the thing is, the reason I came up, and I've had to think about it. I knew, I have believed for many years, and I knew that people shouldn't hire a law firm if the face of the firm, if the person who's creating all the content, the generator of the firm, has no litigation experience. That firm can't be a powerhouse litigation firm. I don't care how many incredible people they have working for it. But I never articulated why. So this time I sat and thought about it. And I came up with the two reasons we discussed. Now, if you don't agree with my two reasons, if you think, no, if you've got great people behind you, it's okay, then that's fine. Disregard the second filter. I think you're making a mistake, but I'm not perfect. I could be wrong. I don't think I am.
Yeah.
If you don't agree, you don't agree. I'm okay with that. No problem.
To echo what you're saying is oftentimes the face of the firm also ends up being the main, primarily, or oftentimes the exclusive shareholder with a very personally vested interest in that firm.
Yes.
And anything that flows and stems from from the top down.
Not always, but yeah, often, sure.
Often.
Okay.
And so the things that you're touching on, including the litigation experience, trial experience, I think it has profound effects, ripple effects that touch well beyond litigation as well, even pre-litigation and the substance and seriousness of the legal work that you perform.
Fair enough. All right.
So, yeah.
Okay. Last filter, folks. Third filter. Strategy and cost should line up. Okay. Now, at this stage, you should be you've gotten through the first two filters. You've done the pre-meeting work. You've looked at the website, done all the article, blah, blah, blah. Now you've met, you've asked the question. They give you a yes. Great. Now you're talking about strategy. Okay. So real HOA lawyers, and when I say that, I'm talking about experienced HOA Davis Sterling Act lawyers, talk in terms of statutory triggers, procedural posture, leverage points. Okay. And they talk about, if you get to that, fee exposure under Civil Code 5975. So basically what happens if we go forward with the litigation against the HOA and it's the proper kind of lawsuit, and they'll tell you what that is. They should be able to tell you that intelligently, okay? Now, these attorneys, these experts in HOA law should be able to explain to you how a dispute typically moves from informal pressure to pre-litigation ADR under Civil Code 5930, okay, to litigation and what changes or what happens at each stage of the way as you progress through that chain, okay? If a firm can't explain cost drivers clearly to you, then they are not going to be able to explain strategy. And if they can't explain strategy, they can't intelligently counsel you regarding likely outcomes. I think that's just obvious. And by the way, hourly rates are not the end all and be all. Lower hourly rates don't always save you money, okay? It can cost you a lot. You often get what you pay for. But I will tell you what does cost you a lot: poor strategy. You hire a lawyer with a lack of experience or poor strategy, you're going to pay a lot more than you would have paid with a higher priced lawyer. Just take that into account. That's all that really means, okay? Now, that's the simple filter. It's the third filter. It's a very simple one, okay? Now, I'm looking at my notes here because we've got a lot to talk about, and we're done with filters, but there's still a lot more. And it's some really important stuff. So let's move on. Because we spent so much time, and we're going to spend a little more time on the same filters, I'm going to go back and revisit our filters again. I want to recap.
Okay.
So those are the three filters. We've discussed the three. There's still a lot more to go. Like I said, this is a special episode. It's going to be longer than normal, but there's a lot of stuff I need to say, and we're going to revisit some of what I've already said and then offer some more examples. But right now, I think it's important to recap the three filters and give a few more examples so that we're clear about what we're expecting, okay? Because we spent so much time discussing the importance of reviewing a firm's articles and other public-facing writings and part of the website, right? I think a brief recap would be helpful. So let's summarize, okay? To summarize, these are the steps, what I've called the filters, okay, that you should take to evaluate the best HOA attorney for you. And remember, number one, the first filter was look at the attorney's website and review a handful, maybe 4 to 7 or 8, whatever. Look at their articles and blogs and ask yourself the following questions. And if the answers to any of these questions is no, then you go elsewhere, okay? Here we go. Are the articles, blogs grammatically correct, clearly written, organized logically to make them easy to read? If a law firm treats their own public reputation with such sloppiness, imagine the lack of care they will apply to your legal briefs and court filings. A lawyer's primary tool, and this is something I say when I train in legal writing, don't I? You've heard me say this over and over and over again. A lawyer's primary tool, in California at least, is the written word. Most things are won and lost on the briefs, okay? If a law firm or a lawyer writing for their firm can't use those words correctly, then how can they ever use them effectively for you, okay? Next, do the articles or blogs provide a genuine analysis and or practical takeaways? Do they read more like keyword SEO dumps where it seems obvious if the author was more concerned with hitting Google's keywords than he was with writing fluently or naturally, okay? Marketing is acceptable and lauded. I think it's great. I use it all the time, right? But marketing should exist to lead you to the expert. It should not act as a substitute for one. In other words, well, I don't need the in other words. I'm going to respect the intelligence of my listeners, okay? If an article feels to you like it was written for search engine robot instead of a human being, it's because the firm probably values clicks more than clients. Keep that in mind. Okay? How much weight you give to each of these is between you and you. Okay? Do the articles, next one, do the articles, blogs routinely refer simply to California law or the law without providing you with actual citations to the Davis-Sterling Act? And I'm not talking about quoting from statutes. That's obnoxious for a lot of reasons. Number one, I don't expect lay people to go and read the statute, but I always give them the option to. Okay? I don't quote cases ever. I won't say never. I almost never will quote case law in an article or brief that I write. I do that, or an article or fact sheet that I write. I do that on purpose. But I routinely, in almost 100% of the articles and fact sheets that I write, will cite statutes that are relevant. And I do that only for the homeowners to go if they want to check for themselves to see if I'm right. I don't want them relying on what I'm saying. I want them to always be able to check me. Am I misstating it? For example, had this other author we've been talking about cited Civil Code 5551 in that article from December about the new laws coming in 2026, and then specifically in the parts about SB 326, had that lawyer cited that code section and somebody been interested enough to look at subsection B1 or F of 5551, which is where they would have found the two issues, who's allowed to do the inspections and what the date was. They could have seen in very plain English for themselves that the 1/1/25 deadline was the correct one, and 26 was wrong. And they would have seen that a certified building inspector was not among the listed people. But that lawyer didn't provide the code section. Now, why? I have my own theories. They could be completely made up. It could be that, and this is what I tend to believe, that this person might not have known the law, to be honest. Okay? Or didn't want to take the time to look it up. Whatever reason it was, and I don't know if those were that person's reasons, but whatever reasons it was, it's a disservice. So, if they're providing you with just, here's what the law is, and they don't at least give you the reference for yourself to look it up, then to me, they're afraid to show their work, because real experts aren't afraid to show their work. Okay? They aren't afraid to cite specific statutes that govern your life. So vague references to the law, to me, in my opinion, are the hallmark of someone who is skimming the surface rather than diving into details. It is the hallmark of someone who has a superficial knowledge of the law, but not a deep knowledge of the law. Okay? And in my opinion, if you are a thought leader or expert in a field, that should mean there's a deep knowledge. That's just my opinion, based on my understanding of very simple English words. Okay? Next, when reading the firm's articles or blogs, do you find yourself getting lost because of sudden references to another state's statutes or to federal laws or regulations or agencies that don't seem to have anything to do with what was being discussed? They don't seem to be logically related to the topic of that article. Okay? And there was no explanation of some sort from the author as to why those might be relevant. If it's lacking both of those, that's a problem, folks. When you see an article that appears to be explicitly addressed to California homeowners and suddenly starts citing Florida law or the federal rules of civil procedure or IRS code, okay? What you're seeing is a lack of supervision at the very best, okay? When a firm routinely slips in laws or regulations from other states or federal agencies into a California forward guide or article, it proves they aren't writing for you. They're running a high volume content mill, okay? They're treating your legal rights like a syndicated blog post where local expertise is sacrificed for broader SEO purposes. And if they can't be bothered to even filter out those extra Florida references or federal references, when they clearly don't fit into a California-centric article, how can you trust them to filter out bad facts in your case? Answer, you can't. Next, are a good percentage, if not most, of the articles or blogs coming from that website HOA-centric, or even more important, California HOA-centric? Now, some law firms like ours and others have offices in other states, like Arizona or Florida or Texas, and that's okay. Their blogs could have both. But if you're in California, there better be a lot of articles about California HOA law. Okay? If you want your HOA to treat, you want your HOA to be an HOA expert in California. I think that's the way I want to say this, right? You want an HOA expert. That's what you're looking for. But someone with deep, you want someone with deep experience with the Davis-Sterling Act. You don't want a generalist who dabbles once in a while in the Davis-Sterling Act, but who does a lot of everything, right? If HOA law is just tucked away into a tiny little part of their, their available articles or their website, then your case is probably going to be tucked away into a tiny part of their office. Okay? Now, I want to be clear about something, everybody. If you remember nothing else about this first filter, nothing, then remember this, because this is the most important message I can get across to you. Poorly written content is a red flag that the firm may be outsourcing its thought leadership to non-lawyers or AI, instead of offering real expertise from experienced attorneys. Just consider that. Now let's talk about the second filter. Evaluate trial experience of the firm's named or managing or whoever partner, okay? As we discussed, it's not enough to have litigators on the staff if the person steering that ship hasn't personally been in the arena. And I think I made it clear as to why. I won't go over all that. Just make sure you get a yes or no, okay? To the question, has the named partner personally conducted jury and bench trials as lead counsel, okay? Legal strategy is not theoretical. It's not a theoretical exercise, okay? It's a skill that's honed through personal experience in the courtroom. You can't buy that from, and AI can't give it to you, and you can't buy it from somebody. You got to earn it the old-fashioned way, okay? If the face of the firm has spent more time in their career marketing than in a courtroom or in front of a judge, then they aren't selling you expertise. They're selling you a brand. And that is not what you need, unless that's what you're looking for. And finally, that third filter, you want to ensure that the strategy and the costs are lining up, okay? A real expert doesn't just talk about fighting. They talk about specific leverage points that they can use from the Davis-Sterling Act. And if they can't explain the strategy behind the spend, they're just guessing with your money. Remember, you aren't just hiring a lawyer to file papers. You're hiring a navigator, okay? If they can't eventually show you a map from initial evaluation through ADR, through trial, they're just as lost as you are probably, and they're charging you for every mile that they're driving, okay? By now, patterns should be obvious, okay? So enough with the filters. Let's talk about red flags that should end a conversation, okay? These are kind of red flags to look out for, okay? Some of this is going to be repetitive, I get it, but I'm driving home the more important points, and this was a hard one to organize because there's so much crossover data that I needed to get out to my listeners, okay? So by now, patterns should be obvious, okay? If you're in a consultation and you encounter any of the following types of things, end the conversation and go elsewhere. Find a different law firm, okay? 1, guaranteed outcomes. If a lawyer promises a win before they've even finished reading your CC&Rs, they aren't being aggressive, they're being dishonest, okay? Although some cases can be described as slam dunks, we describe certain cases as slam dunks all the time. But there are no guarantees in the law. You could have the law on your side, you could have the facts on your side, and still lose a case. Bad judge, bad jury, combination of the two, a lot of things can happen, okay? You could still lose. There is no guarantee in litigation, no matter how much of a slam dunk your case is. So I have no problem with your lawyer saying this is a slam dunk, but make sure you ask, well, does that mean you're guaranteeing an outcome? No. You can lose even if with a slam dunk. Now, is that what normally happens? Of course not. Okay? Next, if you're being pressured to sign the fee agreement immediately, okay, that's a problem. Run. In litigation, there are times when you have to act quickly to preserve your rights. So there are a couple of exceptions. I'm going to give them right now, okay? If there's a statute of limitations deadline looming right on the horizon, or there is a court date imminent and you're about to switch lawyers, or you need a lawyer because you don't have one, and you've got an imminent deadline of some sort, okay? Yeah, in those cases, the firm should push you. You need to do this now because we need sufficient time to do our jobs, and we only got 4 days. And if you wait a day and a half or 2 days to sign this thing, that'll give us 2 days, and we can't do a good job in 2 days. So with the exception of those types of things,
right,
if you're feeling pressure, then you got to run. okay? But absent those two exceptions, okay, if there's no immediate deadline pending or statute of limitations, if you're being pressured to sign right now, for whatever reason, you aren't being counseled, you're being sold, okay? Professional advocacy is a partnership that's based on a deliberate strategy, not high-pressure sales pitch designed to stop you from asking questions, as long, by the way, as you folks are willing to pay for the time it takes to answer those questions adequately. Right. Keep that in mind, okay? Next issue, okay? Evasive answers about experience. If you ask about the named partner and their trial experience and trial history, and their response is not a yes or no, but our firm has decades of experience in litigation, then they're hiding the truth. You need a leader who knows the scars of trial firsthand. You need a leader who understands the reality of litigation. If the face of the firm has no prior trial record to stand on, then they aren't a practitioner, they're a promoter. Hence, they fall into that third category I talked about before. Okay? Next, the publications, the articles, the thing we've been talking about the most. If it's sloppy, inaccurate, incoherent, then run. Because I don't want you to ever forget that same lack of care that led to the word salad sentences and the other problems in the articles we've examined ad nauseum in this podcast. They might lead to missed deadlines or botched motions or a whole host of other things in your case. Because sloppiness and carelessness is usually not isolated to one arena. It's usually a habit.
Yeah.
Okay? Marketing can be bought, but true legal authority can't be faked. I talked about that. Non-nuanced, trite phrases are easy. Deep thought requires experience and scholarship. Okay? Is there anything else? I think I've said everything I want to say on red flags. Did I miss any, Sam?
That was rather complete, Mike. No, I think we can stand on that.
Okay, Great. Perfect. Okay. Guys, we're at the end. This is the end. All right? Ladies and gentlemen, listeners, I want to be clear about why I produced this episode. I did single out a particular firm, and I did single out a particular individual, and I did that deliberately after much consideration and much thought. When someone markets himself as a leading authority and a pioneer in a niche area of law and publishes voluminous content riddled with basic legal errors, and then dominates search results through very effective SEO and paid advertising, the risk isn't abstract. That content shapes how homeowners like you understand your rights. It frames the questions that you're going to ask and influences the paths that you're going to consider when disputes eventually arise. And when that framing is wrong, the consequences could be very serious. I've spent nearly 30 years building my professional reputation in this particular niche area of the law. Okay? I pioneered the strategies and systems that are now used by multiple homeowner law firms or homeowner side law firms in California. I have seen firsthand how much damage can occur when homeowners are steered by inaccurate or superficial information presented as expertise. When misleading content achieves outsized visibility, staying quiet would be irresponsible. And I am not irresponsible. Calling that out isn't personal. It is professional. Folks, this episode was not driven by rivalry or ego. It was driven by the reality that sloppy or erroneous legal content, no matter how polished or well promoted, can distort decision-making in ways that harms homeowners long before an attorney-client relationship ever exists. Now, I focused on one individual because, in my opinion, his influence is substantial and, in my view, is unjustified based on the quality of the writings coming out from that person. And this episode, though, wasn't just about that one person. It's about the difference between a practitioner and a promoter. Now, I use specific examples from one person to give you tools to evaluate credibility for yourself and to see through the gloss. But I wasn't intending to say that there's only one person that's guilty of doing this, okay? Now, in this area of law, credibility has to be earned through accuracy, experience, and performance. It can't be manufactured through marketing, spend, or volume publishing. You deserve representation that has been tested in real disputes, under real pressure, with real consequences by the people setting the tone for the law firm. Use the filters that I gave you today. Demand substance, demand precision, and do not confuse visibility on the internet with competence when your home and your rights are on the line. Now, I invite you to use those tools in evaluating me and evaluating MBK Chapman. I want you to read my articles and fact sheets. I want you to watch my podcasts. I have been first chair in jury trials and bench trials. I can answer yes to those questions. The majority of this firm's work is related to HOA law. I have passed the 3 filters. I welcome the scrutiny, and so should every other attorney out there. If you like this episode, please hit the like button. And if you haven't already done so, please hit the subscribe button. If you have any questions or you want to leave a comment, we love to hear from you. Go ahead and do so. And until next time, folks, have a wonderful day.